each word exactly.
Yeah, we're ready, yeah. Court, rise if able. This is an appeal in the matter of JSC Kazan Oil Plant and Aves failure.
Hold on a second. Yes.
Well, good morning. May I say, first of all, I'm grateful for the dispensation
Not at all.
in terms of roving. I appear for the appellant Kazan Oil Plant, together with Mr. Casriel. My learned friend Mr. Smith appears for the respondent. This is a rolled-up hearing of an application for permission to appeal and the appeal itself, if permission is granted, against an order of Mr. Justice Bright, dated 21st of October 2025, by which the judge struck out my client's application to challenge an arbitration award under Section 69 of the Arbitration Act, as having been brought 15 days out of time. The judge also refused to extend time for bringing the application. Just before I proceed with my submissions, the court asked that we provide copies of the phosphor rules.
Yes.
We have done that electronically. Would it assist to hand up hard copies? We'll
Please
arrange for that. So, the application raises potentially three issues. One substantive, which is appeal ground 1, one procedural, which is appeal ground 2, the extension of time, and one jurisdictional. And the jurisdictional point arises because the respondent says that the court has no jurisdiction to grant permission on ground 1 because of the bar on appeals in section 69(6) of the Act. And that's why this is listed as a rolled-up hearing. Unless the court prefers me to do things a different way, I was going to go first to ground 1 and then the jurisdictional point. I know, in a sense, that's not the logical order, but I anticipate the court will wish to consider ground 1 in any event, so that's how I'm going to do it.
I don't
No. It doesn't seem very logical, but if that's the way proceed as you planned.
Yeah. I'm grateful, my lord. I accept, of course, jurisdiction logically comes first, but, it is a shorter point, the jurisdictional point, and in any event, this is an issue where, as Lord Justice Mayle said when granting permission, or when provisionally granting permission, it is an issue that merits consideration by this court, so I was going to get straight into it. My learned friend Mr. Casriel will then deal with ground 2. And of course, that only arises if I'm wrong on one or both of ground 1 and jurisdiction. Just before I turn to the substance, I'm just going to run through the key dates so that the court has that in mind. I'm not going to say anything about the underlying arbitration, except that it's a phosphor arbitration arising out of a contract for the sale of sunflower oil by my client. There were disputes about liability and quantum. In the end, the tribunal held that the seller, my client, was liable for non-delivery and awarded the buyers around $20 million with interest. That first award was issued on the 27th of March 2024. That's supplemental bundle page 7, just for the notes. The sellers then exercised their right of appeal under the phosphor rules to the Phosphor Board of Appeal. The appeal award was completed on and dated 26th of March 2025. That's page 74 of the supplemental bundle. On the same date, 26th of March, the parties were notified that the appeal award was available upon payment of the outstanding costs. And that letter is, which it is worth turning up, I think, is at page 73 of the supplemental bundle. So the appeal award is now available upon payment of costs, and the outstanding balance was £20,000 odd. And it says, we hereby call upon you, that's my client, as the appellants, to pay the outstanding balance and take up the award. On receipt of payment, we shall release the appeal award to the parties. Now, the judge found, and it's not in dispute, that the sellers were unable to pay immediately because of sanctions. Eventually, they made the payment on the 8th of April, which was a Saturday, and the award was then released on Monday, the 10th of April, which was 15 days after the date of the award. And then at page 152 is a letter acknowledging receipt of the payment and enclosing the award. Now, this procedure, where the onus is on the appellant to pay in the first instance, and the award is then released upon payment, it was not at that time expressly catered for in the phosphor rules, at least not very clearly, but it has since been clarified in the updated rules, which you also have. May I just show you how the rules work in relation to this? If your Lordship were to take first the 2020 rules, which are the ones that applied at the time. And it's,
Miller, can I just ask you, are the parties obtaining a transcript?
that is, I believe we are obtaining a transcript, but not a live transcript. No, yes, that's correct.
There will be a transcript.
There will be a transcript at the end of the day.
Yes.
So it's 2020 rules, and Rule 6, which is on the third page, this deals with, first of all, with first-tier awards, and 6b provides that when the award has been signed, the parties will then be notified the award is at their disposal upon payment. Such payment must be received within 42 days, or the parties forfeit their right to appeal. And then on receipt of payment, the Federation will dispatch the award to the party who's paid and send a copy to the other party. So that's how it works for a first-tier appeals. There is no such specific provision for appeal awards, but in Rule 9b, on the last page, that provides for the procedure and the assessment of the fees, but it doesn't explicitly provide for the procedure for payment. But again, in practice, it was the same procedure that was followed in relation to first-tier awards. And then also of relevance is Article 11C, which says if an arbitration or an appeal award is not taken up by any of the parties within 28 days, the Federation shall call upon the parties to take up the award. That means pay and take up the award. And if they fail to do that, both of them fail to do that, then the Federation may publish a notice to the members of the Council to presumably encourage them to pay up. So that's the procedure.
Can I just go back to the relationship between 6 and 9? Because I haven't read them in detail. 6, you say, deals with, I think you described it first tier awards. You're saying only. In other words, if an appeal process results in an appeal award, but 6 doesn't apply to that for some reason.
That is my understanding, yes, because
because 9 deals with the Board of Appeal shall issue a reasoned award signed by the chairman of the board and sets out provisions that apply specifically to an award made on, well, as it's described, an appeal award.
Yes. Well, my interpretation, I don't think anything turns on this, but my interpretation was that 6 applied to arbitration awards,
Yes.
which are the first tier awards, and then
Yes.
9 is dealing with appeal awards, and then 11C refers to both arbitration and appeal awards. So I don't, my submission would be that 9 doesn't apply at least directly to, 6 doesn't apply directly to appeal awards.
Yeah.
But in practice, that is what's followed. And the position is now clearer, and it's the reason why we provided the current rules. If we go in the 2026 rules, you can see that they've changed in this respect. So Rule 6B on page 4.
Yeah, and that makes it clear. Yeah.
Yes, so that now says that for first tier awards,
Yeah.
the Federation shall call first on the claimant to pay. If the claimant doesn't pay in 21 days, the respondent is asked to pay, and if no payment is made, then both parties are subject to the public shaming procedure or whatever it is entailed in Article 11. And then in 9, there is now an express provision for appeal awards in Rule 9C.
Yes.
There's a more or less identical provision for appeal awards. Now, the other...
the main material difference, as I see it, is that in the new rules, the award is, as it were, held in escrow and is only dated once the payment is made.
Exactly, Marlon, yes.
So you wouldn't get the problem which has arisen in this case.
Exactly, Marlon, that's quite right. So had these rules, the new rules, applied in our case, the claim would have been in time, because the award would have been dated the same day it was released. Now, just returning to the outline chronology, the appeal award, as I say, was released on the 10th of April, and the sellers then issued their arbitration claim seeking permission to appeal against the award under Section 69 on the 8th of May. That was 28 days after the appeal award was received and 43 days after the date of the award itself. We don't need to turn to it, but the claim form is in the core bundle, page 86, and it sets out various questions of law on which the tribunal was said to have erred. On the 18th of June, the respondent tried to strike out the claim form on the basis it was out of time. And then we, at almost exactly the same time, made a cross-application provisionally for an extension of time. So those are the key events for the purpose of ground 1. It may be necessary to look more closely at what happened in April and May for the purpose of the extension of time, and Mr. Kazan will deal with that in due course. The judge gave his judgment on the 21st of October. He refused permission to appeal. His reasons on permission to appeal are at page 84 of the core bundle. The only point to note in terms of the judge's decision on permission to appeal is that he was of the view that the application could be renewed before this court. No submission was made to the judge at that time that there was no jurisdiction to apply to the Court of Appeal. But
I think there was, actually.
I withdraw that.
From my reading of the transcript, Mr. Smith actually took the point, and then the judge said, well, that's for the Court of Appeal to decide.
I'm grateful I withdraw that in that case. Despite that, the judge did indicate that the application could be renewed, but obviously we're here to debate that today. Now, starting with ground 1, then, assuming that there is jurisdiction for now, the question is very simply on the construction of section 70, subsection 3, where the award that is under challenge is the result of an appeal process, whether the 28-day time limit runs from the date of the award or the date of notification of the result. Now, that's obviously a question of construction, and can I therefore show the court the section so that you have the wording in mind? Again, both as it stood at the time and in its new English incarnation. Authorities bundle, page 17. At the time of the claim, section 70, subsection 3 provided that any application or appeal must be brought within 28 days of the date of the award, or if there has been any arbitral process of appeal or review on the date when the applicant or appellant was notified of the result of that process. Now that's since been amended. The new version's at page 26. And subsection 3 now says that an application or appeal must be brought within 28 days of the applicable date. The applicable date is then defined in subsection 3A, and paragraph A repeats the former wording. In a case where there's been any arbitral process of appeal or review, the date when the applicant or appellant was notified of the result of that process. Now, no one suggests that that amendment, so far as it goes, makes any difference. It simply repeats the previous wording. I will have a point to make later on the new wording of subparagraphs B and C and how we say that supports our construction of subparagraph A. I'll return to that in due course. Now, how does the subsection...
How can that be relevant?
Well, to go to the point now, my Lord, it's relevant because the there are three constructions in play. There's ours, there's the judges, and the respondent's notice construction. So I'm going to address all of those. But the respondent's construction in its respondent's notice is that section 73, the second part of the provision, only applies where the appeal process does not result in an award. The appeal or review process does not result in an award. That's the respondent's construction. Now, my point is simply this, that if one looks at paragraphs B and C, those distinguish in a case where there is a material correction, or an application for a material correction, or an application for an additional award. Those distinguish between a situation where that application does result in a material correction or additional award, which is B, and where an application does not result in a correction or an additional award, which is C. And there are different provisions and different dates.
Sorry, I was really making quite a basic in my question, which is how can the wording of the later section throw light on the question?
I see, my Lord. In that case, I'll come back.
The section we're looking at means. For this reason, my Lord, that in my submission, this was not intended to alter the law. This is a codification of where the common law had got to. B and C, so in a sense, one doesn't need the statute. One could make the submission on the basis of the common law, but this is it's clearer just to see it in black and white in the statute. But it's not common law, is it? It's a previous statute.
It's correct. It's the case law applying the previous statute. Yeah. I mean, it may, if I just finish the point since I made it, then I won't have to come back to it. B and C, and reflecting the case law on this, distinguish between a case where an application for a correction or an additional award does and does not result in a correction or additional award. In one case, it's the date of the correction or award, and in the other case, it's the date of notification. A does not do that. Where there has been an arbitral process of appeal or review, it's the same date, whether or not we submit, on the face of the statute at least, whether or not that process does or does not result in an additional award. It's the same date regardless. And that's our point on the new statute and the respondent's construction. Could obviously have broken it down as B and C do into cases where there is an additional award and where there isn't, but it doesn't done that, and we infer from that it's the same date regardless.
You can see the distinction in B and C. In B, where it results in a correction or additional award, it's the date of the award that counts. But in C, where it doesn't result in a further award, it's notification. That rather supports
In my submission, no, my Lord. Respectfully, plainly, if there is no additional award, then it is the date when the applicant is notified of the result of the process, and that's common ground. But one can't, as a matter of construction, there's no reason and no basis to construe A as if it said what C says, what paragraph B says. A simply says, in any case where there has been any arbitral process of review, the date when the applicant was notified of the result. So my point is that it doesn't distinguish between cases where there is and isn't an additional award. Now, one might say, as a matter of logic, it could and should have said what paragraph B says. I don't accept that, and I'll come back to that. But as a matter of simply reading the words on the page, it's very difficult to construe that as providing for different dates, depending on whether or not there's an additional award, because it's simply not what the statute says.
Well, to some extent it's getting into the meat of the argument, but where it's talking about an arbitral process of appeal or review, the question is of what? And that must be, mustn't it, the award which is under challenge.
Well, that's the judge's point.
And so if you get a new award, then you're under D, not A. That's the argument.
That is the argument. That's the judge's reasoning in a nutshell. And on one level, one sees the logic of that, but it does have a number of difficulties, which is, as you say, the meat of the argument, which is what I'm coming to now. Just if I may return to my Lord Justice Miles's point, that we also said that since the wording of paragraph A is exactly the same as the wording of the 1996 Act before the amendments, then it must have the same meaning. So if that's the meaning it has under the new Act, then it must have had the same meaning under the old Act. So that's a further reason why we say that it's helpful to look at. So as I say, there are three potential constructions in play. Our construction, the judge's construction, and the respondent's construction. And let me just identify what they are, and I've covered this to some extent, and make my submissions on them. The first interpretation, which is our interpretation, is that time for challenging an appeal award runs from the date when the appellant is notified of the result of the appeal process, not the date of the appeal award, if that is earlier. And on that basis, the claim was brought in time. The second interpretation, which is the judge's interpretation, as set out in the judgment, paragraph 21, which we'll look at in a moment, is that the words "any arbitral process of appeal or review" refer to, and only to, an appeal or review of the award that is the subject of the challenge. So they don't apply where the award that is challenged is itself the result of a process of appeal or review. If the challenge is to the appeal award, in other words, time runs from the date of the appeal award. And the third interpretation, as I said, is the one in the respondent's notice at Core Bundle 110. That says, in the alternative to the judge's construction, the word should be construed as meaning that if there has been any arbitral process of appeal or review which does not itself result in an award, then time should run from the date of the award. Sorry, just be clear about this. So the second limb of the provision refers only to the situation where there has been a process of appeal or review which does not result in an award. And that seems to have been inspired by the comments of Mr. Justice Hamden's then was in a case called PEC, which we'll look at later on.
How different is that from the judge's analysis?
Ultimately, not very different, but it does have some differences. For example, the judge contemplated a situation where there is an appeal process resulting in award, and the first award is then challenged. Now, leave aside how likely that is or when one would want to do that, but the judge expressly said in his judgment, I would have understood the appellant's case if it was the first award that was under challenge, then time would run from being notified of the result of the appeal process. That doesn't arise on the respondent's construction, because on the respondent's construction, the very fact that there is a further award means that time runs from the date of the original award in that case, and I submit that can't be right, but I'll come to that when I deal with the respondent's construction. But in many cases, they'll be the same. Now, my essential submission is our construction is the most plausible, both as a matter of linguistics, but also for practical reasons, in terms of the consequences that flow from the competing construction. Just the simple but important linguistic point, we say that is the most natural reading of the words, if there has been any arbitral process of appeal or review on their face. That applies to a situation where there has been a process of appeal and the award under challenge is the result of that process. Can I turn then to the judge's reasoning and make my submission why we say that the judge was wrong to construe the provisions he did? Just before I do that, I made the basic linguistic submission. It's perhaps worth just emphasising that there are two features of the language of the provision that we rely on. The first is the words "there has been," which are on their face general, but actually I would submit almost conspicuously and slightly awkwardly general. I'll come back to that point, but if there has been any process of appeal or review, is I would submit a less natural way of describing what the judge had in mind. It would have been very straightforward to say, if there has been any process of appeal or review of the award or in relation to the award, or if the award has been subject to a process of appeal or review. It doesn't say that. It says if there has been any process of appeal, and in my submission that is deliberately wide wording. The other feature of the language is the word any, and again, very broad wording and not easy to interpret as including some processes of appeal and not others. Now, why did the judge reject that? If we
so on your first of those 2 points, are you saying that it doesn't have to be an appeal from the award as a matter of language?
Yes, I'm saying where you have a two-stage appeal process and you're challenging the second of the two awards, the appeal award. Then,
you're not challenging, in court you mean?
Yeah, you're challenging the second award in court.
In court, yeah.
Then that falls within the language because there has been a process of appeal, and time then runs from the date when the claimant is notified of the result of that process.
What possible commercial reason would there be for distinguishing between the two situations? And everyone knows that under phosphor GAFTA you have a right of appeal, and it could result in an award. Why should the very fundamental rule, which we all know so well, which is that time runs from the award, why should it be different if it's an appeal award?
Well, 2 points there, 2 reasons. The first reason is that if a claimant wants to challenge, there may well be cases, there will, in my submission, be cases where the claimant wants to challenge both awards because there's been some...
So you get 28 days from the first and 28 days from the second?
Well, yes, but before you can challenge the first award, you have to exhaust your appeal process. That's section 72.
Yes.
So you can't appeal the first award until you've exercised the arbitral appeal right. But if when you are notified of the result of the appeal award, there may be cases where you want to challenge both awards, because the appeal award may say appeal dismissed, and the first award remains enforceable. one might then want to challenge both awards. And in some cases, it will simply be a matter of drafting. You might plead the challenge as saying, both, seeking the remedy of setting aside of both awards. Alternatively, you might say, I simply want to vary the second award so that instead of upholding the first award, it sets aside the first award. It's a matter of drafting and pleading to some extent. But in substance, one may well want to challenge both awards if they're both vitiated by the same problem. Now, if you want to challenge both awards, it makes no sense, in my submission, to have different dates, to have to bring two challenges on two different dates in relation to two awards that are affected by the same problem. But more than that, on the judge's approach, the time for challenging the second award would run before the time for challenging the first award, and that is very bizarre.
What you're doing there is you're allowing what would be a vanishingly small number of cases, a very rare situation, to dictate the construction of the entire regime. And the situation which you're going to be appealing both awards is going to be very, very rare.
Well, I'm not sure that it will necessarily be rare. As I say, it may just be a matter of how the claimant chooses to draft the claim. But
I can't remember having seen it, I have to say.
well, but there will be such cases in my submission, and it doesn't make a lot of sense. For if that is the position, then it results in a rather absurd situation. But the other point, my lord, is that it's not a direct answer to your question, but it is a point that needs to be borne in mind. The judge's construction in my submission leave the second limb of the section with practically no work to do, because the second limb of the provision applies, well, if in order for the second limb to be engaged, there obviously has to have been a process of appeal or review. But the challenge must then be to the first award, not the appeal award. Now, your lordship put to me, well, that's never going to happen in practice. But in my submission, this is something which is difficult to imagine happening in practice. If there is a process of appeal or review resulting in an award, why then do you need to challenge only the first award? Because that's the only situation on the judge's construction where the second limb is ever going to apply.
Well, isn't it where the appeal is, for some reason, it comes to an end, but without an award? So, for example, it's not hard to think of examples, but there's some procedural failure, which means that for example, failing to put up security or paying the costs of the original award, which means that the appeal process comes to an end. The appellant is treated as having exhausted its remedies under the relevant sections, and then it wants to bring an appeal to the court, and it then has 28 days from the time when the arbitral body has notified it that the appeal process is at an end.
Yes, I see that. So in practice, that brings the judge's construction essentially into line with the respondent's construction, which is that the section only applies where the appeal process does not result in an award.
Well, couldn't you have numerous schemes where there can be a process of review which results in a refusal to alter the award?
You could have that, yes. I mean, obviously, we're concerned with appeals in this case, but there could be review procedures that don't result.
You can request a reconsideration or a review, and the tribunal either refuses to, or as a result doesn't change the award.
Yes, so that's another example of a case where there's an appeal of or review process which does not result in an award, and so That is
Well,
essentially.
it does result in an award, then you have your 28 days.
Yes, so
That's the argument.
that's the respondent's construction. Yeah. So now I've been dealing with the judge's construction, and I've submitted that. I mean, on a linguistic level, it's a reasonable construction, although in my submission, not the most obvious, clearest construction. But it does have awkward consequences in at least the case where both awards are challenged, and it means that the only practical situation where the subsection, the second half of the subsection applies, is where there is no award, and so for that reason, it is in practice indistinguishable from the respondent's construction.
Can I ask you about that? If the procedure at appeals is that the board will issue a reasoned award. What is, in that context, an award? In other words, is it simply the outcome of the appeal, or is it only an award?
In the context of the phosphor rules,
yes.
It's an award, and it has the same status as any arbitration award.
But so what would be the outcome? I mean, if you get the letter of the 26th of March and it says the appeal award is ready, do you know until you've seen it? I mean, for example, if the appeal had been dismissed because of some procedural or technical error, would you know that from that wording, or would you need to see the award before you knew what the result of the process was?
If the appeal was dismissed on any basis, you would not know that until you received the award. It's possible that the party could be notified at some earlier stage that the appeal wasn't going to be considered, or it had been struck out, or something because of some defect. But subject to that, the result will only be known.
The letter doesn't, on the judge's construction, doesn't indicate whether you're in the second limb or the first limb. You could be within both.
Yes. There is going to be an award because you've been told the award is ready.
I understand that.
So on the judge's construction, the time for challenging that award will be on the date of the award.
I appreciate that, but what I'm trying to establish is whether the appeal award could be your appeal is dismissed on procedural grounds, which is what the judge says is the event outcome to which notified of the result of that process applies.
No, in my submission, in that situation, the time would run from the date of the award, whatever the basis for the decision was. So if you wanted to challenge that second award, time would run then. Now, if the appeal had been dismissed on some procedural ground which left the first award intact, as it were, and one wanted then to challenge the first award on the merits, well then time would then run from the date when the claimant was notified of the result of the appeal.
But then the challenge would be, as you say, to the first award, not the appeal award.
Yes. Now, I probably covered what we say about the judge's reasoning, but maybe just go in the judgment to see what the judge said. Page 67 it starts, but the core of the reasoning is at 76. The judge has just referred to the decisions in UR Power and PEC, which I'm going to come back to later, but he says at 19 that the judges in both those cases essentially agreed on the fundamental point. Any challenge under the Arbitration Act to an appeal award must run from the date of the appeal award. I'll have submissions to make about that, but that's his starting point. Excuse me. Now, at 20, the judge says that I don't find this mysterious or puzzling. Any challenge must relate to an award. It therefore is entirely natural that the first limb of section 73 sets out the primary or default position in relation to the running of time by reference to the date of the award. Now, I don't take issue with that so far as it goes, but in 21, the judge goes on to say, when understood in this context, the second limb, referring to any process of appeal or review, must mean any arbitral or review, appeal or review of the award that is intended to be the subject of the challenge. Now, and where there is not or cannot be any arbitral appeal or review of the relevant award, the second limb doesn't apply. Now, my submission is that whether it's the conclusion is correct or not, it is a non sequitur in terms of reasoning. Just because the normal position is that time runs from the date of the award, doesn't follow that the second limb must be read as only relating to an appeal against the award under challenge, and as opposed to the appeal award being the result of the appeal process. It's really assuming what needs to be proved by a process of reasoning.
But the judge is referring back to the whole of 20 there, as I read it. And the first sentence of that is saying any challenge under these sections must relate to an award. This being where the tribunal's reasons are set out, and then that's reflected in the words of the sections. And that does seem to have some force to it, that what one's dealing with in each of these sections is a challenge to the award. So that when you then look at 70, which is the bit under which we're looking at, when in 73 it says any appeal must be brought within 28 days of the date of the award, I think the point the judge is making is that the natural reading of that is that there has to be an appeal against that award. That's the natural focus of the section. And so he says, you ask which award is being challenged, is there an appeal against that?
Yes, and I accept that there's a reading and one, it's a perfectly logical way to structure the system. In principle, my submission is simply that it doesn't logically follow that it must mean that. Of course, a challenge must relate to an award, but it's logical to assume that at least in most cases, the second limb is going to apply to the award that is under challenge. But one does ultimately have to construe the words, and you'll also have my submission that it doesn't say that the.
Don't we though have to look at that in the context of the section as a whole, and in particular section 72? So we're looking at an appeal against an award, and what 72 says is that you can't bring it unless you first exhausted arbitral process of appeal or review. Now so there is the same formulation, appeal or review, but that is an appeal or review of the award that you're seeking to appeal. Must be.
Yes.
So when then you come to 70, subsection 3, any application or appeal must be brought within, and it then says process of appeal or review. So that's referring back to the same process of appeal or review, which you just accepted must be an appeal or review of the award you're challenging.
I don't accept that with respect. 72 obviously does require you to exhaust any available process of appeal or review, but if there has been, if you've done that, then in my submission there has been an arbitral process of appeal or review.
But not of the award that you're now seeking to appeal.
No.
And that's the judge's reasoning, and it seems to me it's difficult to follow that.
Well, I don't.
Because of what it means in 72A, you are you are asking us to read it differently in 70 subsection 3 than it means in 72A, aren't you?
Well, the wording is not exactly the same. Two is any available process, and as opposed to any arbitral process of appeal or review. But
no, that makes sense because when you're barring the appeal, it's if there's an available one. But when you are looking at the time limit, the time is extended if there is an appeal or review. So I'm not sure the word available is surprising that is used in 2A.
yes, well, in my submission, one doesn't need to, as it were, interpolate the words of the award that is the subject of the challenge. It would have been straightforward to include wording to that effect. There are different ways it could have been done. Instead, it says there has been any arbitral process of appeal or review. My submission that the most natural way to read that is including our situation, and that is because, as I said, it's likely to be because there are cases where it would make no sense to have different dates applying to different awards.
The other point is that seems to me to give some support to the judge's reading is that the whole basis of this is that it's an appeal on a question of law arising out of an award made in the proceedings. That's 69. So you have to identify a point of law arising out of an award. So you have to identify the award. And if one looks back at 69, there are all sorts of things that the court can do in respect of an award. So under 7, confirm the award, vary the award, remit the award, set aside the award. It's got to be about the award. It's not some sort of general challenge to the arbitral process in some more nebulous sense. And then when you read 70 in the light of that, isn't there force in the judge's point that the process of appeal or review has to be in respect of the award, that award which you're challenging?
I don't, with respect, accept that necessarily follows. Obviously, I accept that the challenge has to relate to an award.
But why should it be a different award? Or how could it be a different award?
It's not that it's a different award. It's simply that the statute says where there has been any process of appeal or review. And in my submission, that is wide enough and deliberately wide enough to capture an appeal or review in the proceedings in which the award has been made, and therefore to capture a challenge to either award. And that's because it makes sense to have one cut-off date for challenges to any award made in that process, whether it's the first award or the appeal. And I accept that from one end of the telescope, as it were, it looks unnecessary or illogical to have that extension where one is challenging an award that cannot itself be the subject of an appeal or review. But that is accepting that oddity is necessary in order to avoid the other oddity of different dates for different awards.
But the counter to that is that it then produces in what is a very common scenario of an appeal award, completely cuts across the whole rationale for the 28 days from the award in the DAC report, and you're going to take us to the authorities. But you're sacrificing the certainty, which is recognised to be so paramount, and replacing it with a party being able to effectively, by deciding when to pay, decide when to set the time running.
Well, I mean, 2 points on that. First of all, there is obviously a category of cases where Parliament has decided that time should run from the date of notification, not from the date of the award. And so just saying that there needs to be certainty, and it was intended that there should be certainty, it doesn't really answer the question of which cases belong in that category, because there are clearly some, and the only question is this one of them?
Well, that's because if it's not an award, then there isn't a date of an award from time to run. The only thing you can have is notifications.
Well, absolutely, but I've made the point already that the subsection doesn't only apply where there is no award. I mean, that is clearly not what it says. It says where you're notified of the result of the process, and that must include cases where you're notified by way of receiving the final award, just as it does if you're told that the appeal or the process has been stopped for some other reason.
Can I ask again, sorry, based on, of course, relative ignorance, if the phosphor decide, if an application was made to phosphor and phosphor it was decided that they didn't have jurisdiction, so the claim was dismissed, that would be an award, or is that a decision? Is award defined as a term of art anywhere? And presumably you could appeal from that decision. You could say, well, you're wrong, you do have jurisdiction. We want you to exercise your jurisdiction.
So, if it could be in some cases that the appeal board decided it had no jurisdiction, but it could be that, and then there is I think PEC is an example of this, that there was a challenge made, but wrongly made, because in fact there was no jurisdiction to consider a challenge to the first tribunal's jurisdiction. And that then was held not to be an available process of appeal, because there was simply no jurisdiction to entertain an appeal. But if there is jurisdiction to entertain the appeal, then that will then result in a further award.
Well, awards on jurisdiction are very common.
Yes, exactly.
And in fact, the Arbitration Act provides, doesn't it, that the arbitrators have jurisdiction and
Yes.
determine their own jurisdiction.
Yes, but I think that there may be differences of approach depending on which institution you're in, as to whether
Yes.
you can appeal a first-tier award on jurisdictional grounds.
Yes.
And if you can't, then there is then no available process of appeal, and so you're not in that limit.
Yes. I think the point, but the important point is an award on jurisdiction is still an award.
Yes, yes.
Because I'm still trying to work out what is the result, what is the result of the process other than an award? When will the result of the process be something other than an award? And I take an award just to mean a decision or equivalent of a judgment.
Yes. Well, I think my Lord Justice Miles posited a situation where the appeal is terminated for some other reason, because there's some procedural failing, like you failed to pay cost, and so it's terminated without any consideration on the substance.
And that's not an award.
That wouldn't be an award. That would just be the process coming to an end for some other reason.
Don't we have an example?
Okay.
There's a case in the bundle, isn't there?
Yes.
Is it X against Y?
That's right. It's,
Or A, is it? No, A against P, sorry. different letters. It's in tab.
yes, tab 8 of the
usually one
authorities.
Yeah.
So that's a case where the tribunal decided it had jurisdiction.
So your submission was a result of that, the words notified of the result of that process are extremely limited in their application.
My submission, I think, was that they're broad in their application in the sense.
No, I understand that, but if they only apply when there's been something like that, then
yes.
they're extremely limited in their application.
Exactly. Yes, it is quite difficult to think of situations where there would be an appeal process, and a review may be different. A review won't necessarily result in an award, but an appeal almost always will result in an award. And of course, as my Lord Justice Phillips has said, these sorts of rules, phosphor, GAFTA, and so on, are very commonly applied, and they invariably result in appeals, in appeal awards. And certainly one wouldn't then need to challenge only the first award, which is what the scenario the judge alluded to when he said he would have understood our point if our challenge was to the first award. I was coming just to the respondent's construction. As I say, that is squarely to say that the subsection only applies to an award which has been the subject of an appeal or review, and the appeal or review has not led to the issue of a further award. Now, in my submission, that requires some fairly radical redrafting of the section, and I've made this point already. The subsection is entirely unqualified. It says where there has been any arbitral process of appeal or review, and it's impossible in my submission to read that as somehow only applying to an arbitral process of appeal or review which has not led to an award, as opposed to one that concludes in an award.
Just in terms of how the way it works, as I understand it, is you have a first tier award, let's say. You cannot bring a Section 69 challenge against that award for so long as there is an appeal available. But there will probably be a time limit. As soon as that time limit expires, there is no longer an appeal available. At that point, you can bring the Section 69 appeal.
Well, there might then be an issue as to whether, if you fail to use a process of appeal when it was available, it was then open to you to go to the court.
In that scenario, you'd be out of time.
But yes, and then, as Mr. Kazan reminds me, in that case, there would not have been a process of appeal. So it would be the date of the award, if you could bring a challenge. So it involves doing some violence to the language, and I've made the point that gains added force from the new wording of Section 70, which distinguishes between processes of correction or processes of additional awards which do and don't result in a correction or an additional award. In the former case being time running from the date of the correction or award, and in the latter case time running from date of notification. In subsection A, it's the same date, on the face of things at least, regardless of whether there is or is not an additional award. And that's essentially a statutory enactment of the case law that is synthesised in the Daewoo case, the decision of Mr. Justice Bryan, which is in the bundle. Now, the other problems with the respondent's construction are similar to the problems with the judge's construction that we identify. It still gives rise to the oddity, if not the absurdity, whereby a party who seeks to challenge both awards must challenge them at different times. And it may even mean that the challenge to the first award has to be brought while the appeal process is ongoing, because if the appeal process eventually results in an award, then the time for challenging the first award will have begun to run from the date of the first award. That would be very strange.
Why do you say that?
Why do I say it would run from the date of the first award? Well, because time either runs from the date of the award or from the date when you're notified of the result of the appeal process. So, on the respondent's construction, if there is a further award, then that second limb doesn't apply. The second limb only applies where there is
it doesn't apply to the second award. no reason why it shouldn't apply to the first award.
No, because with respect, the respondent's construction is that it doesn't apply at all where the process of appeal results
See, this
in...
is the difference between the judge's construction and the respondent's
Yes.
construction.
Yeah.
Well,
So
that may well be a reason why the judge's construction is to be preferred.
well, the judge's construction is, if anything, preferable to the respondent's construction. I would agree, but it still has the problems that I've been addressing. The third related problem with the respondent's construction is that, again, it leaves the secondary with very little work to do, and in a phosphor type case with practically no work at all to do. The second limb expressly refers to arbitral appeal processes. Most arbitral appeal processes, as I've said, certainly Phillips and others, do result in appeal awards. And Parliament must have known that both in 1996 and in 2025. And it's very unlikely that Parliament would have used the wording any arbitral process if, in fact, it intended to exclude arbitral processes that don't result in that do result in awards. That would exclude the vast majority of arbitral appeal processes. So, to sum up where we got to, both the alternative constructions, the judges and the respondents, have serious difficulties in my submission. The judge's construction, I'd accept, is a plausible interpretation, linguistically speaking, but would lead to odd and inconvenient consequences in practice. The respondent's construction would also have odd consequences in practice, but in my submission, that's not even really an available interpretation of the statutory language. Certainly not the most likely interpretation. And both of the constructions would render the second limb inapplicable and irrelevant in virtually all cases where there is an arbitral appeal, even though the statute says it applies in every case where there's an arbitral appeal. So, in our submission, our interpretation is the only one that is both faithful to the text and also sensible and workable. Just to conclude on this, may I show the court briefly the authorities where this has been arisen? And it's not so much that they illuminate the answer to this question, but of course they're relevant to the extension of time question, because the judge's essential reasoning on the extension of time was that we should have known when time started to run, and it was clear enough from these authorities. So I think if I cover them now, it will save Mr. Casual from doing that. But the first one is UR Power. That's at tab 4, page 67. This is the only one that actually purports to decide this question at all. But it's the decision of Mr. Justice Gross in a phosphor case. And it's very much like in our case. The award was dated 20th of November. The claimant was notified on the 15th of December, and the claim form was issued on the 9th of January, so within 28 days of notification, but more than 28 days after the award. And can I just invite the court to read paragraph 58 on page 78, and then going through to 60.
Yes.
I'm grateful. So the judge held the claim was out of time, but if it had had merit, he would have granted an extension of time. A number of points about the reasoning. First, the judge, with respect, doesn't actually arrive at any definitive construction of the provision. He just says that whatever it means, it doesn't apply to phosphor or GAFTA appeal awards. So, with respect, it's not a very satisfactory piece of analysis for our purposes. It begs the question why the statute doesn't apply to phosphor or GAFTA awards. The judge gave two reasons for the thesis that phosphor and GAFTA appeals are excluded. The first, that subparagraph 2, the bottom left side, is that the alternative construction would result in different cut-off dates applying to different parties. Now, there are at least two problems with that. The first is that it's not factually correct, at least as a general statement as applied to today's world. I've shown you under the phosphor rules that the award is released to both parties at the same time as soon as someone pays for it. And that's probably the case under any sensible institutional rules. Maybe the judge had in mind other sorts of problems like delays in posting awards to people, but I think even by 2009 email was commonly used. But in any case, there's no reason to think that is a serious or a common problem today. The result will inevitably be released to both parties by email at the same time. The second and more fundamental reason is the one I've made already, that there plainly is a category of cases where time does run from the date of notification, and that, if that results in different cut-off dates for whatever reason, well, that's simply what Parliament has legislated for in that category of cases. So to say that there should not be different cut-off dates as a matter of principle is therefore, with respect, irrelevant and not an answer to anything. And the same objection can be made to the judge's other reason, subparagraph 3, where he refers to the DAC report. And again, the need for certainty, and we all understand that. But the problem is that however disadvantageous or unattractive it might be in principle for time to run from the date of notification, the fact is that the statute says in terms that is when time runs from, at least in a category of cases, namely where there has been a process of appeal or review. So, again, it doesn't, with respect, answer the question.
I think the point that arises there is that generally in relation to awards, the legislature has taken the decision that it's the date of the award, not the date of notification.
Yes.
Appeal awards of this kind, FOSCO awards, are, in any common sense view of it, just awards. I think that's the point that the judge is making. Why should there therefore be a difference?
Yes, well, Your Lordships, I think I have my submissions on it, because that is what the statute says, if there's been any process of appeal, and there has. And the advantage of that is it means there is one date for challenging both awards. And that is a sensible arrangement where there are two awards that may potentially be the subject of proceedings. And it also gives effect to the statute. Everyone agrees that these wording is slightly mysterious, and no textbook.
Well, the judge didn't.
The judge didn't. No,
he didn't find it puzzling.
No, he didn't. But everybody else who's considered it before has found it odd. And it's the fact that there is a category of cases it applies to, and one has to consider which is the most appropriate and sensible way to treat it. And in my opinion, given the breadth of the wording and the practical implications I've talked about, then ours is the more sensible. The second case is PEC, which is at tab 6, page 88. And this was a GAFTA case where an award was issued on the 2nd of July 2012, and an application was made to the court more than 28 days later. At that time, the GAFTA appeal was still pending, but the appeal did not relate to the same subject matter as the court proceeding. So the application to the court was made in relation to jurisdiction, whereas the GAFTA appeal was on the merits. And the court held there that the time began to run from the date of the award on jurisdiction, not the date when the result of the appeal was notified, because there was no appeal in relation to the jurisdiction award. On page 90, in paragraph 14, the judge held that under the GAFTA rules, the first tribunal's determination on jurisdiction was conclusive, and that was therefore the only relevant award, and there was no available process of appeal in relation to that award. At paragraph 17, he then considered the further submission based on UR power that section 73 didn't apply to GAFTA appeals, and he expressly did not follow UR power in that respect. He said at 18 that it is difficult to see how the GAFTA appeal procedure is not an arbitral process of appeal. Moreover, neither party was able to identify any arbitral process of appeal other than those such as GAFTA and phosphor. So an express rejection, or at least doubting, of the suggestion that the subsection doesn't apply to phosphor awards. The judge then went on to say that Mr. Justice Gross made a forceful practical point, that time should run has been recognised to run from the date of the award rather than from the uncertain time of notification, which might differ as between the parties, and I've already explained to your Lordship why we submit that isn't actually a forceful point at all, because it doesn't answer the question of which cases belong in the category that's expressly mentioned. So it's not right to say that the time shouldn't run as a matter of principle from the date of notification. And then at the end of paragraph 18, Mr. Justice Hamlin concluded by saying that a possible answer would be to construe section 73 as imposing a different time limit of 28 days from notification of the result of the arbitral process of appeal or review, as applying in case in which the appeal or review does not culminate in award. Where it does culminate in award, then it's from that date of award that the time runs, and that's the Respondent's notice construction. Now, in answer which it's not really clear what question the judge was suggesting a possible answer to. He seems to have been trying to construe the section in a way that it would include GASFA and phosphor arbitrations in principle, but limit the scope of the second limit of the provision to prevent it from applying to the majority of GASFA and phosphor cases. Now, with respect, that's, in our submission, not the right way to approach the question of construction. One shouldn't start with a presumption that the statute shouldn't apply to the situation at hand and then find a way of construing it to give effect to that. But in any event, in our submission, the judge's suggested construction is unconvincing on its own terms. He had himself earlier noted that the parties hadn't been able to think of any arbitral process of appeal other than phosphor and GAFTA and similar schemes. But those schemes, as I said, do invariably result in an award. And, the phosphor rules 2020 say in Rule 9b that the Board of Appeal shall issue a reasoned award. I accept that in some cases the appeal could be withdrawn or something like that, but then one presumably wouldn't need to be notified of the result in a formal way, as in the case of an award. But in any event, I've already said when addressing the Respondent's construction that it's just difficult to reconcile it with the words of the statute. Now, the only other authority I was going to show the Court is Russell, the textbook, because that contains somewhat inconsistent statements in different parts of the book. But again, this is maybe relevant when you come to consider how clear all this was when you consider the extension of time application. But it's page 225. Paragraph 670. It says, a few lines from the top, time runs from the date of the award, whether or not it's been notified or delivered to the parties. And the footnote 278 says a party seeking to challenge or an appeal against an award must first exhaust any process of appeal or review. And if such process exists, the 28-day time limit runs from the date when that party was notified of the result of it. And it is unclear why a different approach has been adopted, so as to make notification of the result, rather than the date of the decision, the trigger event for a challenge or appeal following a process of appeal or review under the arbitration agreement, it's been suggested this was not applied to two-tier arbitrations under the trade rules such as GAFTA and FOSTA. But as we've seen, that suggestion, it was suggested, but that suggestion was rejected by Mr. Justice Hanlon and is not part of the judge's reasoning in our case. Then paragraph 8186 on page 226 is from a different chapter of the book, specifically addresses section 73, and it states that under section 73 an appeal must be brought within 28 days of the date of the award, or if there has been any arbitral process of appeal or review, e.g. an additional award, from the date when the applicant was notified of the result of that process. So if there has been an additional award, not if the award is an additional award, or if the application relates to that additional award, but simply if there has been a process of appeal.
But what status does this have with authority? Just expressing a view, isn't it?
It's expressing a view, yeah.
Unreasoned view.
Well, like any practitioner says, it's expressing, obviously the point isn't directly covered by case law, it's mainly case law, it's expressing the author's view. So it has the weight that one gives to a practitioner's textbook, but it also goes to the point, as I said already, it will go to the extension of time points and whether this is something that was so clear that anybody ought to have realised it. And in fact, the textbook, at least at this point, says that it was more consistent with our construction. And then it goes on to say, in the footnote 634 at the bottom of the page, an additional award may result from a request to the tribunal or from an appeal board established under the rules governing the arbitration. So there's some ambiguity.
But insofar as we were taking this as the general knowledge for the purposes of extension of time, then the footnote that you've already shown us to directly applies to this situation.
The footnote that says that it's been suggested that it doesn't apply to FOSTA and GAFTA. Yes, that does apply, although of course it's misleading because the authority refers to wrong on that.
The state of knowledge that parties would have through reading this textbook. That's the only.
I see that model, yes, but if one then looks at the paragraph I'm now on and the footnote 634, that says that where there has been an appeal award, time runs from the date when the applicant was notified of the result of that process. That's
Yeah.
So there's a degree of inconsistency there. Certainly not a clear statement in favour of the judge's construction or, for that matter, the respondent's construction. And as I say, that's relevant to the extension of time. But that second section I showed you, in my submission, does indicate that appeal awards are covered in principle. And I also suggest that it supports my case that the second limb of the section applies where there has been an appeal award and not just where the challenge is specifically in respect of the appeal report. So the appeal award. So that concludes my submissions on the substantive point, and we respectfully submit and invite the court to decide that the time for challenging an award runs from the date of notification in any case where there has been an appeal or review of the award, whether or not the challenge actually pertains to the appeal award itself. I was going to turn to the jurisdictional point. Now, the starting point for this is section 69.6, which is page 15 of the authorities. And that says, the leave of the court is required for any appeal from a decision of the court under this section to grant or refuse leave to appeal. It said that includes the judge's decision to strike out the claim for failing to comply with the time limit. Now, our fundamental submission on this is that the position is covered by authority, and specifically the case of Peel and Colin Park, which is tab 5 of the authorities, page 80. And this was an application under sections 68 and 69, which was brought out of time. And the judge had refused an extension of time, and the claimant sought to appeal, and as here, there was a rolled-up hearing. And at paragraph 13 on page 84, Lord Justice Longmore said that Mr. Wood, the landlord, had conceded that there is in principle jurisdiction to grant permission to appeal. Then he says, of course, that must be right, since section 85 requires that the rules of court relating to extending periods of time apply in relation to any time requirement. And so we have the slightly paradoxical situation that whereas the refusal of the judge at first instance on a matter of substance under section 68 or 69 cannot be reconsidered by this court, an application of a preliminary nature for extension of time is apparently a matter which can be reconsidered by this court. So the court did have jurisdiction to grant permission to appeal, but it refused permission on the merits. Now, just unpacking what Lord Justice Longmore was saying, and I'll come to the status of it in a moment, but just to be clear about what the judge was saying, he's making a point about section 80. And if you go to section 80, which is at page 20, subsection 85 says, where any provision of this part requires an application or appeal to be made to the court within a specified time, the rules of court relating to the reckoning of periods, the extending or abridging of periods, and the consequences of not taking a step within the period prescribed by the rules apply in relation to that requirement. So the point is that although the 28-day limit itself is prescribed by section 70, the question of extension of time is governed by the CPR, and the power to extend time arises under the case management powers in CPR 3.1. So a decision to refuse or grant an extension of time is a decision under the CPR, specifically CPR 3.1. It is not, in the language of section 69.6, a decision, quote, under this section to grant or refuse leave to appeal. It's not a decision under 69 at all, but it's certainly not a decision to grant or refuse leave to appeal. Now, that's what Peel decides. Now, it's common ground that Peel is good law, and that as a decision of this court, it is binding in relation to what it decides. And that concession is rightly made, notwithstanding the fact that the issue was not disputed in Peel itself. We cited the authority for that proposition, that to say that a case is still binding even if the point is conceded, footnote 5 Vasquez on page 23. And as I say, it's not in dispute. And moreover, as we saw, Lord Justice Longmore didn't just record the agreement between the parties, he expressly said it must be right that a decision on extending time is not called. So it's therefore common ground the court has jurisdiction to grant permission on ground 2 of this appeal. What is in dispute is whether the court also has jurisdiction to grant permission on ground 1, and we say that it does because the logic of appeal, in fact the reasoning of appeal itself, it applies equally to a decision to strike out the claim because of a failure to bring it in time, as it does to a decision to extend or refuse to extend time. And if we go back to section 85, it expressly says the CPR apply in relation to 3 things: reckoning of time periods, extending and abridging periods, and the consequences of not taking a step in time. So what happened in this case? The judge found that the claim was brought outside the time allowed, and as a consequence of that, he struck out the claim. Now, striking out is a power that arises under CPR 3.4, just as granting an extension of time is a power under CPR 3.1. There's no material difference between those types of decision. Either they're both caught by 69.6 or neither of them is. And Peel decides, bindingly, that neither of them is. And we said that's the short answer to the jurisdictional point, that it's covered by the Peel case. Now, Moylan relies on some more recent cases where, arguably, the courts have taken a more expansive view of the bars on appealing in sections 67 to 69. There are at least 4 Court of Appeal decisions on this point in the last 5 years that I'm aware of. 3 of them are in the bundle. I can just summarise what they are, but I don't propose to go to them in detail. First of all, Manchester City, that's tab 10 of the authorities, that's the decision about publication of a judgment in an arbitration appeal. That was held not to be caught by the bar on appealing, so the court could grant permission to appeal. Secondly, National Iranian Oil, that's tab 11, a decision that the claimant was barred by Section 73 from bringing its challenge under Section 67 because it could have raised the objection during the arbitration. So it was precluded from bringing a challenge later because it was out of time. And the reasoning essentially was that Section 73 is part of the machinery of deciding challenges under Sections 67 to 69. And so a decision that a claim was barred by Section 73 was part of the process of deciding the challenge under 67. And so that was caught by the bar on appeal. Diag Human, that's tab 12, it's a decision on security for costs under Section 70, subsection 7. That was also caught because, again, Section 70 has no application outside this part of the Arbitration Act. It's part of the machinery for deciding arbitration challenges, and a decision on security was part of that process. And then the fourth one, which is not in the bundle, but I'll mention it anyway, is a case called P&ID in Nigeria, where a decision about the costs of a Section 68 challenge was under appeal, and the court decided that was not caught. It did have jurisdiction to grant permission to appeal, as did the Supreme Court, as the Supreme Court later itself granted permission to appeal for a further appeal. So there are two on one side of the line, publication of judgments and costs, and then there are two on the other side of the line, Section 73 bar and security for costs under Section 70, subsection 7. Now, what this shows is the question is quite fact sensitive. There are, as I say, decisions on both sides of the line, and no doubt there will continue to be litigation about where the line is to be drawn in a particular case. I would agree that National Iranian Oil and Diag Human in particular do take a fairly broad approach, and it might even be that if appeal were decided now, it would be decided differently in light of those cases. I say it might be because the reasoning in my submissions is still valid, that a decision on extensions of time and a decision to strike out a claim are made under the CPR, not under the Arbitration Act, and they're not decisions on to grant or refuse permission to appeal under Section 69(6). So I would say they're more on the Manchester City and Nigeria side of the line than they are the Iranian Oil and Diag side of the line. But so I wouldn't accept that appeal would be decided differently now, but it's possible that it might be. But the point is it doesn't matter because appeal has been decided, it's accepted to be good law, it's binding, it covers this case, and that should be the end of the matter.
Do you say, forgive me, just to understand, do you say Peel has actually decided at this point?
I say that, well, what it decides is that an extension of time is, a decision on an extension of time is not caught by the... Section 85 provides that decisions on extension of time are governed by the CPR. Michael's, their reasoning applies squarely to this case. It is impossible to distinguish this case from appeal because the only difference is that one is about an extension of time, the other is about the consequences of not complying with the time period. But both of those are expressly mentioned in Section 85. Both of those are powers that arise under the CPR, are imported into the Arbitration Act by Section 85. And so the reasoning in Peel squarely applies to our case. One can't distinguish it as a matter of principle. One could only distinguish it on the facts, but there's no reason to do that.
But the extension of time is not a matter which is provided for in Section 70.
No.
Whereas the time limit is provided for by Section 70. That time limit isn't provided for elsewhere in the CPR.
No.
So, and we're not talking here about reckoning the period of time. you're talking about interpreting Section 70, a decision that interprets Section 73. So I'm not sure it is right to say that it's obvious that the analysis of Lord Justice Longmore in Peel does apply to this situation. I mean, I can see it's arguable. It may be arguable, but I'm not sure it directly applies.
Well, the submission is that the judge's decision was a decision, and his order is an order striking out the claim. That's his decision, because there'd been a failure to comply with the time limit. And it happens to have been the 28-day time limit in Section 70. But he struck out the claim because there'd been a failure to comply with the applicable time limit. Now, that is something that Section 85 says in terms is governed by the rules in the CPR. The decision that time started running on the date of the award, I accept that's a decision applying and interpreting and applying Section 70. But the subsequent decision and the operative decision and what gives rise to an appeal is his order striking out the claim on that basis. And we submit that striking out the claim for failure to comply with the time limit is squarely a matter that's mentioned in Section 85, and that's the power that he exercised. And so we are squarely within what Peel decides. But
forgive me, just get be a bit more granular about that. Looking at 80 subsection 5. How do you analyse that and what happened here?
So, Section 85 applies the rules of court relating to three things: reckoning of periods, extending.
Firstly, taken out first. That's not something that was done under the rules here.
No. Because there was no
But
issue
under
as
Section
to
70.
What happens if something is served at a particular time of day or something. That's not. Extending or abridging periods.
That's
that
the
was
separate question.
Yeah, that's ground 2.
Yes.
And then this is the part I rely on: the consequences of not taking a step within the period prescribed by the rules. And
But that's not what we're looking at. We're looking at the time prescribed by statute.
well, our appeal is against the order striking out the claim because a step wasn't taken within the period prescribed by the rules. Now, the section,
Which rule?
the rule in Section 70. So,
No, that must mean the CPR, doesn't it? The rules of court. It doesn't mean the statute.
Is your submission, as I understand it, that what this section is saying is that where there is a statutory time limit, because that's a bit at the beginning of subsection 5, so it says where a provision requires an application to be made to court within a specified time, then you use the rules of the court for reckoning, extending, and working out what the consequences of that failure are.
yeah.
There isn't a separate rule with the CPR saying this case must be brought within this time, but the consequence of not doing it within the time limit, as I understand it, your argument is that's been decided by the court in the exercise of its rules, powers, if you like, and it's decided to strike it out. I mean, the court could presumably, although it's very theoretical, just have granted a declaration saying the appeal is out of time, but then it would have just been left in a sort of limbo state, and what it did was strike out the claim.
Yes, I suppose it could also have or refuse to grant permission to appeal, which would be within the wording of Section 69(6).
And what if it had done that?
Well, a decision that refusing to grant permission to appeal would be within Section 69(6). But I do have my primary submission is that we are squarely governed by appeal for that reason. But I do have second submission, that if I need it, which is that it would be bizarre and unsatisfactory, my submission, if the court, having jurisdiction, as we all agree it does, to grant permission to appeal against a grant or refusal of an extension of time, not to have jurisdiction to consider the primary point of whether the claim was in time at all. I mean, it really is quite illogical if the court can consider only one of those two things, when very often they will be both in play, and it's quite difficult to, or artificial to argue one in isolation from the other. So if you don't accept that appeal actually governs the case, that nevertheless the fact that appeal governs what it does govern is a strong pointer towards the court having jurisdiction in this case, and it, as I say, being on the Manchester City side of the line rather than the Iranian oil side of the line, because it is not it's not dealing with a decision to grant or refuse permission to appeal. I promised Mr. Kazan I'd sit down at 12, which I haven't quite managed to do, but subject to your lordships, those are my submissions on the jurisdiction.
No. Yeah, thank you very much.
Okay.
Yes.
Forgive me, just. My Lords, I'll address the court on ground 2, which relates to the judge's refusal to grant COP an extension of time to bring its Section 69 appeal pursuant to Section 80, subsection 5 of the 1996 Act. I start with the following general points. First, this ground only arises if the court is not persuaded on ground 1, or doesn't grant permission on ground 1. If we succeed on ground 1, COP's Section 69 appeal was brought in time, no extension is required. Ground 2 is therefore pursued strictly in the alternative to ground 1. Second, I do not shy away from the fact that the refusal to grant an extension of time is a discretionary case management decision, and as such I have a high hurdle to surmount on appeal. It's necessary for me to persuade this court that the judge's decision A was wrong in principle, and or B took into account irrelevant matters, or failed to take into account matters which should have been taken into account, and or C was so plainly wrong as to be regarded as outside the generous ambit of discretion entrusted to the judge. However, it is my submission that one or more of those criteria is satisfied in this case. Third, the extension sought is 15 days, which corresponds with the delay experienced by COP in obtaining a copy of the appeal award after it had been issued by the Phosphor Board of Appeal. The appeal, just to remind you, Lordships, Mr. Milner's already addressed you on this, but the appeal award was issued on the 26th of March 2025. It was received by COP on the 10th of April 2025, 15 days later. COP then issued the claim form on the 8th of May 2025, which was 28 days after it had received the appeal award, and, if the court is not with us, on ground 1, 15 days after time had expired under Section 73 of the 1996 Act. Fourth, it follows that the entire 15-day extension sought is referable to and explained by the delay experienced by COP in receiving the appeal award after it had been issued by the Phosphor Board of Appeal. COP was not in a position to start making any progress towards issuing its Section 69 appeal. Indeed, it did not even know it had been unsuccessful before the Phosphor Board of Appeal during this period of delay. Once COP had received the appeal award and was in a position to start making progress towards issuing its Section 69 appeal, it did so within 28 days. Fifth, the judge accepted that COP was not at fault for the 15-day delay between the appeal award being issued and it being received by COP. Paragraph 35 of the judgment, the judge records that the principal reason for the delay from 26th of March to 10th of April 2025 was that the claimant, that's COP, had difficulty in remitting the funds required to Phosphor because of sanctions. This I regard as excusable so far as it goes. Sixth, although the judge was of the view that COP ought to have realised that time expired 28 days after the appeal award was issued, he accepted that COP did not in fact realise this. At paragraph 36 of the judgment, the judge records that unfortunately the claimant did not appreciate that only 12 days remained. He then goes on to explain how COP's Russian lawyers took the view that time only started to run from the 10th of April 2025, and at paragraph 37, that Madison Legal, my instructing solicitors, also understood the position to be that time ran only from the receipt of the appeal award on the 10th of April 2025. That this is not a case where COP acted intentionally in making an informed choice to delay making the application, as was the case, for example, in the Turner Bahrain case, at paragraph 30, Mr. Justice Popperwell as he then was. Seventh and finally, by way of my general points, it follows from what I've said that there can be no suggestion, and there is none in the judgment, or from my learned friend, that COP was guilty of deliberate or tactical delay, as was the case in the Turner Bahrain case, see paragraph 74 of that judgment. My lords, I'll now address the court on what I submit was the judge's error of principle, and then I will later make submissions on what I submit was the irrational aspects of the judge's decision. The judge identified the principal factors relevant to the exercise of the court's power to extend time as being those summarised in the Kalmnecht case at paragraph 59, Mr. Justice Coleman, which can be found in the authorities bundle, tab 2, page 43. And perhaps I might just invite my lordships to read that paragraph, paragraph 59. So, my lords, there are 7 factors or considerations identified there. I submit that a further relevant consideration arises in cases such as this, where the applicant does not receive the award on the date it is issued, such that time starts to run against the applicant before he has even seen the award. Now, you could think of that as an 8th consideration in that type of case, or you could simply see that as part of the 7th consideration, whether in the broader sense it would be unfair to the applicant for him to be denied the opportunity of having the application determined. That consideration is not relevant on the facts of Kalmnecht, but of course it is relevant on the facts of this case, assuming that COP is unsuccessful on ground 1. Yes, sorry, Mr. Milner reminds me, of course, that situation wouldn't arise under the new phosphor rules, but of course it may arise. It arose under the phosphor rules as enforced in this case, and it could arise under different institutional rules, depending on what they provide. So where there's been a delay between an award being issued and it being released to the would-be applicant, such that time has started to run against the applicant before he's even seen the award, I submit that the relevant question is whether or not the applicant is at fault for the delay. If the applicant is at fault, for example, because he took a deliberate decision not to pay the tribunal's fees, with the result that the award was not released to him, then no extension of time is warranted. But if he is not at fault, as in this case, then in my submission, prima facie, he ought to be entitled to an extension of time so that he is not deprived through no fault of his own of the 28-day period afforded to him under section 73 to consider his position and make his application. In those circumstances, an extension of time simply puts the would-be applicant in the same position as he would have been in had there been no delay between the award being issued and it being released to him. And that, in my submission, is the only fair outcome in a situation where the applicant is not at fault for the delay. Otherwise, the applicant is prejudiced by having his time eroded through no fault of his own.
Wouldn't that mean, in principle, replacing the words of the section with a different one? So that time would begin to run from the... If this is a matter... You're saying this is a matter of law, of principle. It would mean that the absent fault, the test should be read as saying 28 days from the date of notification of the award.
Yeah, well, my lord, it's a point my learned friend makes. And in my submission, it's a straw man, because it's not my submission that time's automatically extended where there's a delay. You still have to apply an extension. You still have to persuade a judge that it wasn't your fault. You'd have to bring evidence to prove that. And of course, the judge would still retain a discretion not to give you an extension, taking into account all the circumstances of the case. I mean, my submission is only that...
Sorry, I'm so sorry, I interrupted you. Please carry on.
No, I mean... I was going to say, I mean,
Yes.
my submission is only that there's a prima facie... I mean, perhaps putting it as a right is too big, but there's a prima facie entitlement...
Sorry, the prima facie rules, you have to do it within 28 days.
Well, you could... Perhaps, my lord, thinking of it in Les, the starting point is you have to do it within 28 days. That's what the statute says, assuming we're wrong on ground one.
Let's say you only get the award 2 days after its date. So you have 26 days left. But you take 28 days. You had 26. You take 28. You say you should prima facie have the extension.
Well, you may not need the extension if you have
you know that you had 28 days, but you say that prima facie you should have the full 28 days. You say.
Well, my lord, as I say, it's only if you can. Firstly, you have to make an application. So I don't say that there's any automatic extension.
Forgive me,
and you'd have to persuade the judge that it wasn't your fault. And if there was if for example there was prejudice, the respondent, then that would obviously be a circumstance in which the judge may not grant an extension. But I mean, one of the factors.
But what this amounts to is this: you get the award 2 days after its date. You've got 26 days. It's not your fault you didn't get it for 2 days. But then you say, okay, well, prima facie we are entitled to an extension. So we have the full 28 days. So we're going to take our 28 days. And then we're going to go to court and say, well, it wasn't our fault. So prima facie we should have the extension. Even though you knew that you should have done it within 28 days. Well, that cannot be right, can it?
Well, my lord, respectfully, there are two elements as part of your question. The first is about whether, in principle, you should have the 2 days. The second is about the timing of the application, because I appreciate I'm going to have to meet this point, because in this case, the application was made after the expiry of the deadline. But someone who just, as you say, helps himself to the 28 days when he should only have 26, that application might be seen in a different light to the applicant who in advance. I mean, if the applicant
prima facie, as it wasn't your fault, you're entitled to 28 days. That's your submission.
Well, my lord, my submission is that it's a factor in what remains a discretionary exercise of the court's power.
Forgive me, I think you're saying this that the judge erred in principle because he didn't adopt that approach.
Well, my lord,
you are saying it is a legal principle which the judge failed to apply.
Well, there's no recognition at all, my lord, in the judgment of the fact that the extension of time sought was in respect of the period of delay for which COP was not at fault. So, I mean, perhaps if
it's a bit unreal to think that the judge wasn't aware of what he was dealing with. I mean, he knew how long you needed in order to have done it within time. and he went through all of these extremely well-known factors in the Calmlef case, which commercial court judges deal with day in, day out. And one of them is whether in the broadest sense it would be unfair to the applicant for him to be denied the opportunity of having the application determined. It's extremely broad. Also, the words at the beginning are, each case turns on its own facts. These considerations are likely to be material. So any judge dealing with this discretion knows that it's fact sensitive. Seems quite unreal to me to suggest that the judge didn't understand the basic point, which is that there had been a period of 15 days, or whatever it is, when you didn't know the outcome of the award. That's the whole point of the application.
Well, I mean, I can jump into the judgment on this. I mean, this is skipping ahead because I was trying to establish the point of principle, and it may be that the point of principle I'm saying is actually so obvious that you're saying, of course, the judge considered this. But my submission is that I mean, in my submission, it is obvious that Parliament has legislated one should have 28 days. If that period is eroded, now if the period is eroded by 2 days, I mean, it's difficult because, of course, one of the factors is the length of the delay. And so, in a sense, it cuts both ways, because if it's only 2 days, you might say, well, that's a reason to grant an extension. After all, it's only 2 days. And indeed, the judge's approach was to say 15 days was too long, and that was a factor that was used against COP. Now, I'll come on to that. In my submission, that's irrational, because actually, once you take into account that COP was not at fault for the 15 days, and once you recognise that the 15 days was the period for which it was not at fault, delay in receiving the award, actually, and this is a point touched on by my Lord Justice Phillips, the length of the delay is actually a factor in favour of an extension, because the more delay there is, the more time has been eroded from the 28 days, and for reasons which are not the fault of the applicant. I mean, one could imagine a situation where the full 28 days is eroded. So if you only get your award 28 days after it's been issued, for a reason that's not your fault, you then have essentially you have no right to appeal at all. In my submission, it would be perverse in that situation to say, oh, because you're asking for a 28-day extension, that's a very long time, because it's the full statutory period, you don't get an extension. I promised my Lord Justice Miles that I would turn up the relevant part of the judgment. Which is, it starts at paragraph 32, which is on page 80, tab 8, page 80 of the core bundle. And then, sorry, at 33, he makes the point about 15 days being a long period of time. I'll come back to that. 34, he says the critical factor in this case must be whether the claimant acted reasonably in permitting the period of 28 days to expire. So note, the critical factor for the judge is not whether COP was at fault for the delay. The critical factor is whether, and skipping ahead, I mean, essentially what this boils down to for the judge is, should COP have realised that it only had 28 days from the date of the award? That's the critical factor on which the entire application for an extension of time turns, as far as the judge is concerned. He then, at 35, he notes that the principal reason for the delay was that the claimant had difficulty in remitting required funds because of sanctions. This I regard as excusable so far as it goes. However, if the claimant had appreciated that it only had 28 days in total, he should have been at pains then to use the remaining 13 days effectively. So, in essence, the judge's reasoning is, well, tough luck. If you'd realised you only had 13 days, you should have brought your application within 13 days. And so there is a failure in my submission to recognise what I submit is an obvious principle, that where there's a delay that's not your fault, you ought to have an extension, but of course that is still discretionary, and if there are reasons not to give you an extension, then so be it, you don't get an extension.
I don't read the judge as with respect, as going wrong in principle here. He's just weighing up these factors, which he set out from the Calmner case. I mean, for example, if you had come along and said, look, this is a massively complicated case. The award runs to 1,000 pages, which isn't unusual in commercial arbitrations. We actually needed, just in order to do the physical work, say 28 days. That might have been a different case. I think what the judge is saying is, look, you got the award, there's no satisfactory evidence. Sorry, you ought reasonably to have realised that you were up against it, and there's no satisfactory evidence that you got on with it. That's what I understand him to be saying.
Well, I don't, my lord. I mean, I don't see that in the judgment. Him saying that.
Well, he says that you didn't. Then he's saying
you should have been at pains.
It should have been at pains to use them effectively, and then it goes on to deal with what actually happened. It says that one of the points that's being made is that in 38 is that work didn't commence then for another. What was it, 9? Didn't actually commence until the 24th of April. And he says, well, that's not excusable. So he's just going through this in a fairly conventional way, isn't he?
My lord, again, the starting point is that an applicant has 28 days.
Well, the starting point is that the
20 days from the
applicant
date
has 28 days from the date of the award.
Yes.
That's the starting point.
Now, if you don't receive the award for some period because you don't pay, then no circumstances, there's no rational reason why you should then have an extension. But if it's not your fault, why all I'm saying, my lord, is, well, why should you be in any different, why should you be in any worse a position? I mean, I can see the point that you may have different reasons to ask for an extension if it's a hugely complicated case and it's a 1,000-page award and so on. That's a separate issue. You might need more than 28 days in that situation, and that's something you can ask for. But everybody's entitled to 28 days, regardless of the case, regardless of how complicated it is. The starting point is everyone has 28 days, unless you get the award late, in which case you get less than 28 days. And my submission, that's...
Okay, though, everyone is entitled to 28 days from the date of the award.
Yes, my lord. And if you...
You're not entitled to 28 days from the date of notification. That's ground one.
But in the normal case, you'd be notified of the award on the date of the award. I mean, that's the ordinary case. And if there hadn't been...
What you're really saying is that the court should approach it on the basis that the starting point is 28 days from the date of notification.
If the applicant can persuade the court on an application that it was not their fault, firstly, and secondly, that in all the circumstances of the case it's just to grant an extension. I can't put it higher, my lord, than that it is a highly relevant factor to take into account on an application for an extension of time. It remains part of the judge's discretion.
But isn't the analysis this? You have 28 days from the date of the award. If you have less than that because you no fault of your own, you don't get it for a period of time. You have less time. Now, but nevertheless, the period is the same. It's 28 days. So then, it seems to me you've got to go to the judge. And there are two answers to that. One is that the statutory time limit doesn't give us enough time. We need more time. Classic extension of time. It was 28 days. We've only got 13. That's not enough time. We need more time. That's one basis. The other is, well, actually, we misunderstood how long we had. Now, it seems to me you didn't argue one. You didn't say we didn't have enough time to do it. So we're left ground two. We misunderstood. Now, at that point, the question the judge asked is that a reasonable excuse? That's the question he asked. And wasn't that the right question in that situation?
Well, my lord, in my submission, no. The would-be applicant is entitled, I submit, to say we ought to have 28 days because that's the period. Plainly, if you need more than 28 days, because of the complexity of the award or so on, that's something you have to ask for. But in my submission, if all you're seeking really is the 28 days which you're given by the statute, if you're asking for that 28 days, you're asking for time to be extended in order to give you the 28 days that you should have had all
it's
along.
The wrong starting point. If you get, let's imagine that you don't get the award for 15 days for no fault of your own, and you appreciate it early enough that you make an urgent application to the commercial court saying, we haven't got this, we've only just got this award. We appreciate that time expires in 13 days' time. Please, Mr. Justice, Mrs. Justice X, we need an extension. Now, at that point, everyone understands that the time will expire in 13 days. And the fact that it wasn't your fault is plainly a factor in your favour. But prima facie, what you've got to persuade the court is that you need more time. If it's a very simple, straightforward appeal, a judge would say, well, unfortunate you didn't get it for 15 days, but you can easily do it within the next 13 days. You'd have to explain to the judge why you need an extension of time. And there's no principle, it would be no good going to the commercial court judge and say, well, we're entitled as of right to effectively to an extension to the full 28 days. That's not how it would work.
Well, my lord, I mean, one could have. I might answer the point with this hypothetical. If the full 28 days had been eroded, so I mean that's a situation that the DAC consider in their report because perhaps you can conveniently see it in. It's actually in the judgment. Extracted. It's extracted in UR Power, which is itself extracted in judgment, paragraph 14, page 72, of tab 8 of the core bundle. About a third of the way down the page, there's a quote. It's possible that the time limit under clause 73 will have expired by the time the award is released. So the DAC they're considering the specific situation of where the entire time has been eroded. And then they explain that nevertheless they're going to have time running from the date of the award because of the need for certainty. And then the final sentence, further, any difficulties arising from specific circumstances can be easily remedied by way of an extension of time. So the DAC plainly envisaged that if the entire time was eroded, you'd ask for an extension of time.
But you'd still have to then say to the judge, just on the example that's given, okay, I now need some more time. The judge will say, well, how long do you need? He won't just say, or she say, okay, you can have 28 days. They'll say, just as on any extension of time application, the court always needs to know how long you actually need, how long is justified. It might be a week, it might be 3 days, it might be 46 days.
But my submission, my lord, that
but there's no tariff, as it were, which says that you start at 28 days.
well, in my submission, that's unprincipled, my lord, because Parliament has said you should have 28 days. The Parliament doesn't say you should have. I mean, I think it's acknowledged that the 28 days is already quite a short period. There's references to the need for it to be a short period because of the need for finality in awards.
It is,
so on.
it
It's
is
a short period.
The principle is that if you have an extension of time, the principle is you have as much time as is just and reasonable in all the circumstances.
And in my submission, what is just and reasonable in all the circumstances is 28 is to bring you up to the 28 days so that you're not prejudiced through the delay that's experienced for a reason that's not your fault.
Okay, yeah. Thank you.
Well, you have my submissions, my lords. So I've already said, just, I can probably skip some now. Bear with me. Well, so those are my submissions on the principle, my lords. I think I've covered all of that. I'll move on to what I say with the utmost respect to the judge. I submit that his order refusing an extension of time was irrational in the sense that it took into account irrelevant factors, failed to take into account matters which should have been taken into account, and/or was so plainly wrong as to be regarded as outside the generous ambit of discretion. To make that good, it's necessary to examine the judge's reasons carefully, and they're set out in the judgment at paragraphs 32 to 41. In my submission, the key relevant factor which the judge, I've already made this point, of course, the key relevant factor which the judge fails to take into account is the fact that COP was not at fault for the 15-day delay. This warranted an extension of 15 days to afford COP the period to which he was prima facie entitled. You've had my submissions on that. Then returning again to the judge.
He did take it into account, but that's exactly why he analysed whether you were at fault.
The fault there is the fault that he analyses is whether we were at fault for realising that the time expired 28 days after the award. He reaches, right. He states that we were not at fault for the 15 days, but in my submission he doesn't properly go on to take that into account as a reason for granting an extension. He doesn't say anywhere that that's a reason for granting an extension. As I say, he simply moves on to what he, in my submission, respectfully, mischaracterises as the critical factor.
Well, sure, it's 34, he says, that the critical factor is whether that you acted reasonably in permitting the 28 period to expire. So then he says, as far as the first 15 days are concerned, it's excusable. So yeah. He is taking into account that the first 15 days delay was excusable.
Yes.
And then he goes then to consider the next 12 days.
But if there's in my submission, if there's 15 days of excusable delay, that ought to be met with a 15-day extension. It's the simple point. I don't know.
Well, that's the same point. That's the
same point, my lord.
That's the point of principle, isn't it?
Yes. So then
But he does. But as far as what he did take into account, that the first 15 days of delay were excusable.
Well, he says that the first 15 days are excusable, but he doesn't then take that into account when he decides. He doesn't say. I mean, he doesn't say, my lords. He doesn't say you could have brought this. He doesn't make a finding. This application could have been brought within 13 days. 13 days was enough. That's not his finding. All he actually does is says you should have realised that time expired 13 days later, and therefore you should have used that time.
Well, it wasn't.
It doesn't actually say it was enough time.
It wasn't suggested to him by your side, was it, that they couldn't have done it within the 12 to 13 days left?
Well, they didn't realise that they had to.
No,
that was their submission.
But it wasn't submitted to them. It wasn't submitted to the judge. We couldn't do it within that period.
Well, they didn't do it within that period because they thought they had 28 days from, as you know, because of ground one. Their position was that the 28 days ran from the date on which they were notified. They took the steps needed to get the work done in the time that they thought they had available to them, and that was a mistake. Assuming we're into ground two, that was a mistake. The question is then whether that was an excusable mistake. And perhaps I should. I'm being told as well. Of course, there was a change of solicitors from Russian solicitors who were acting in the arbitration to English solicitors who were acting in the English proceedings. That, of course, took some time. That process could only start on day 16, as it were, because before that they didn't know they were going to be bringing an application before the English court. So you see that in paragraph 36, my lord.
Yes.
They were represented by Russian lawyers, and then it changed lawyers in mid-April, and then and the claimant's solicitors, and then the last sentence, Very level legal solicitors took steps to instruct English solicitors for the first time. And then the claimant solicitors, Madison, were not able to take on the case until 22nd of April. And the letter of engagement was not signed until 24th of April, by which time had already expired. And it's not traversing the judgment, my lord, but it was in the evidence before the judge that the reason why for the delay in instructing Madison legal was also because of sanctions. There were difficulties in arranging an engagement letter with Madison because of those sanctions reasons. So, I mean, it's not addressed in the judgment, but there were further delays within the 13 days because of sanctions. Yeah. So, my lords, turning then to the critical, what's said to be the critical point. Now, it's important to emphasise here that the judge does not say, in contrast to what my learned friend says in his skeleton at paragraph 56, this factor is critical because it goes to the question of whether COP should have made its application for an extension of time before the expiry of the deadline. Rather, the suggestion seems to be that if COP had acted reasonably, it should simply have appreciated that it only had 13 days to prepare its Section 69 appeal from the date on which it received the appeal award, and it should therefore have made its Section 69 appeal within the 13 days. And you see that in paragraph 35, which I've already shown you. That, in my respectful submission, is irrational. That COP or its lawyers did not appreciate that time had started to run is at best completely irrelevant to the question of whether an extension should be granted as a matter of principle. If anything, though, in my submission, it's a factor pointing in favour of an extension, because somebody who mistakenly gets the deadline wrong might be thought to be more deserving of an extension of time than someone who knows what the deadline is and misses it anyway. And so what the judge seems to have done in my respectful submission is confuse the question of whether an extension of time should be granted as a matter of principle with the separate question of the timing of the application. The judge would have been entitled to say, Hallam states, that since this was an application for an extension of time made after the expiry of the deadline, it should be treated as an application for relief from sanctions. And in that case, the question of whether COP ought to have appreciated what the deadline was would have been relevant to stage 2 of the Denton test, whether there was a good reason for the breach. But nowhere in the judgment does the judge apply the Denton analysis or say on what other basis COP's appreciation of the imminency of the deadline was relevant. Had the judge applied the Denton analysis, he would have, of course, been required to consider all the circumstances of the case as part of stage 3, which in my submission required him rationally to consider the balance of prejudice, the fact that COP was not at fault for the initial delay, which I've already addressed you on. In other words, there was no rational and principled basis for the judge to sideline all other considerations in favour of what he, in my respectful submission, wrongly treated as the critical factor. So my primary submission on this factor is that what the judge considered to be critical factor was not in fact the, or even a critical factor at all, but rather one factor among many. Alternatively, I submit that the judge was in any event wrong to regard COP's error as unforgivable, which is what he says in paragraph 40, with the result that COP should in effect be punished with the most draconian sanction available, strikeout, for a simple and excusable error of interpretation of section 73 of the 1996 Act. I make 8 points in that connection, 8 short points. First, COP was entitled to take the words of section 73 at face value, at least as its starting point. And you've heard from Mr. Milner on the meaning of those words. And for my purposes, it's sufficient that it must have been at least reasonable for COP to have read the words, if there has been any arbitral process of appeal or review, as having been triggered in this case, because there was an arbitral process of appeal or review. Second, Mr. Justice Gross, as he then was, found the meaning of section 73 to be puzzling, quoting his judgment in UR Power at paragraph 58. And if Mr. Justice Gross found the meaning of the provision puzzling, my instructing solicitors may perhaps be forgiven for not having been able to solve the puzzle or not having solved it in the same way as the judge did. Third, it was reasonable for Kopp's lawyers to seek assistance from the leading textbook, Russell on Arbitration, and you've already been shown this by Mr. Milner, but what that textbook says is that time runs where there's been an arbitral process of review or appeal from the date of notification. And I'll pick up one point actually on that, which is that I don't need to turn it up, but there was a discussion with Mr. Milner earlier about the fact that it refers to UR power in a footnote. But of course, all it says about the case is that it's suggested. It doesn't apply to phosphor and gas. It doesn't say that it was held not to apply or that it's binding in that connection. Fourth, both the judge below and my learned friend placed great emphasis on the fact that UR Power and Peck reached the conclusion that time actually runs from the date of the appeal award in cases such as this. But those judgments in my submission were of limited utility to Kopp at the time it was considering its position. Briefly, in UR Power, the point is dealt with obiter. Mr. Justice Gross expressly says that he expresses no concluded view as to the true ambit of the words if there has been any arbitral process of appeal or review. He says he's tentatively attracted to the view that they don't apply to phosphor or GAFTA appeals, and that was a view which was subsequently said to be wrong by Peck and by the judge below. Peck is also obiter and didn't even concern a case where it was argued that time to bring a Section 69 appeal against an appeal award runs from the date of notification of the award. Rather, that was a case where the issue was when time started to run for the purposes of a challenge to a first instance award, whilst an appeal on a different point was ongoing. So they didn't answer the riddle for Kopp. Fifth, the judge's own reasoning did not accord with either UR Power or Peck. And you've had submissions on that from Mr. Milner. So there are now 3 judgments at first instance, which all seek to explain Section 73 in different ways. Sixth, in light of that, I respectfully endorse what Lord Justice Males said when granting permission to appeal in this case, which you can see in the core bundle, tab 12, page 106, where Lord Justice Males, in giving permission, said that ground 1 involves an issue which merits consideration by the Court of Appeal and on which there is no clear previous authority.
But if a lawyer is advising a client and sees that a limitation period may expire on date A or later date B, they're going to make sure they issue proceedings by date A, aren't they?
Well, if the lawyer reaches the view that it's not date A and in fact it's date B, then he may well advise the client to issue on date B.
What you're showing us is that material suggests that it may be date A, but it may be date B.
Well, I think, my lord.
I mean, you can't dispute because a lawyer should advise their client to issue by date A.
I mean, there was a mistake made. I mean, if we're in ground 2, my lord, I mean, it's because we've lost on ground 1, and therefore I can't hide from the fact that there was a mistake made.
But forgive me, you seem to be suggesting that looking at all these materials justified a decision to go for date B. But surely what the materials would show any lawyer properly doing their job is that you should go for date A.
My lord, the submission is that it's not clear on these materials.
Well, I think that's and the judge, I think, accepts that it may not be clear. But his point is that, isn't it, is that having these judgments having been available for more than 15 years and have been referred to in the textbooks, the general understanding is clear cut. But in any event, whether it's right or it's wrong, it was that view is plainly expressed.
My lord, with respect, that's not what the judge says. What the judge says is that it was clear that the time expired on what we're calling date A, because he doesn't say it's unclear and that's why you should have gone for the earlier date. He says it was clear that it was the earlier date, and therefore your decision to go for the later date was unforgivable. But paragraph 39, this is how he, paragraph 39 is how he distinguishes, because of course in UR Power and in PEC there were extensions. Well, in UR Power there was no extension, but Mr. Justice Gross said that he would have granted an extension had the merits warranted it. And then and in PEC there was an extension. And in paragraph 39 of the judgment, the judge distinguishes those cases on the basis that because of these two earlier cases, it's now clear. So he says that about halfway down, in UR Power, it was the first time that it had come to be, that this point had come before the court. There were no authorities to consider their mistake of ruling was perhaps forgivable. And in PEC, it can't be ignored that they'd agreed it. And then furthermore, the only authority on point was the obiter view of Gross in UR Power, which was still relatively recent. And then at 15 years have passed since those cases. Subject to the difference between Gross and Hamblin, as the former's comments at paragraph 60, both judgments have been adopted by the leading textbooks. In my submission, that's not right, and you've seen the leading textbook. The general understanding of the profession, which Gross adverted to and which I have recognised, has become ever more entrenched. I find it difficult to regard the claimant's error as forgivable. And so perhaps I don't want to overstate, my submission is simply that the claimant's error is forgivable. But I have to accept that if we're in ground 2, it was an error. And I'm saying it was a forgivable error because the state of the law was unclear. It remained unclear.
I just wonder though whether that's a fair reading of the judgment as a whole. I think if you go back to 37, isn't what the judge is saying, look, the state of the law was, in fact, unclear. So he says that they ought to have warned Madison Legal of the perilous position that the claimant was in. And it is akin to the case where there may be a debate about when the limitation period is, but a prudent lawyer will therefore say to the client, look, it's unclear, we better get on with it. And as I read the judgment, this part of the judgment as a whole, what he's saying is it was unclear what the position was, and any reasonable lawyer would have realised that. And what Madison Legal thought was that they didn't do it, but that can't be a basis for an extension of time. They ought to have got on with it because the position was unclear. And so he's not saying at the end, I'm punishing them because they got the wrong answer. He's saying when they got this into their hands, they should jolly well have got on with it. And that then goes back to paragraph 35, where he says once they got the award, they should have used the remaining 13 days effectively. So it's all in the context of that.
Yeah. And of course, my lord, you've had, of course, Madison Legal don't come onto the scene until after
yeah, but he doesn't think much of that point either, because he says that that's not, he deals with that in 38 and says the fact that there's the change of lawyers isn't an answer. So that deals with the period up until the 24th of April.
And we've answered, we've made a submission on that point actually on paragraph 38. It's in our skeleton. I can turn it up. It was actually dealt with in the evidence before the judge that they had taken advice from an English SIL who had acted for them during.
Well, that's debated.
I think that's debated. I don't know. I don't know if you're going to be assisted by me showing you that evidence. I can if you.
But that, with respect, that's a slightly different point because this is about the change of lawyers. Yes. Effectively, what the judge is saying there, as I read it, is we can't rely on that chunk of time, as it were, or rather excuse that chunk of time, because that was just your client's decision to change lawyers when it did.
Yeah. Of course, my submission, my lord, of course, this is all coloured by the fact that the claimant didn't know that it only had 13 days. And
No,
there's
but
the question of whether
that
it ought to
goes
have
back
been.
to the question of what the judge meant when he said
And so
it
it's
was a
whether,
perilous position.
yeah. And so your I understand your question, my lord, is that if I read the judgment, you say if you read the judgment as a whole, it's not about punishing or whether it's forgivable. It's simply that if it's the prudent thing to do is to go by the earlier date. But my lord, it's difficult to reconcile that reading of the judgment with the way in which the judge distinguishes UR power and PEC, which are cases where the commercial court has said that they would grant, either did grant or would have granted an extension of time. Because the judge says the difference between this case and those cases is essentially now you have the benefit of those cases. So
Yeah,
they're
but
saying
so
the law
now
is-
you know
the
that
law
we're
is
in a
that-
perilous position.
but you might, the ambiguity was there anyway. And it was unclear before. It's still unclear now, in my submission. So if you were a litigant said to be worthy of an extension because of the lack of clarity in the law at the time of UR power and PEC, you're still in that position because those authorities don't resolve the point, in my submission, or don't resolve it in a way which is clear. So in those circumstances, I mean, that really is the end. I mean, in my submission, it was irrational to treat COP's error of interpretation, essentially, of the Act as unforgivable. And there should have been some leeway. It was rational to grant the extension of time. My lords, there's one... Sorry, I'll just have a look at the time. There's no clock.
There's one on over
I
there.
think I have... Oh, OK, I have... One very, very short point, final point, my lords, which I'll mention, but I don't urge on this court. To the extent that this court is prepared to look at the decisions of first instance judges, exercising what I accept as a discretion, the decision of the judge in this case doesn't really conform with the trend of the authorities in the commercial court. In general, when it comes to extensions of time to bring challenges under sections 69 to 70, sorry, section 67 to 69 of the 1996 Act, the trend is that relatively short extensions have been granted where the applicant is not at fault for delay. And so you can see that, for example, in UR Power and in PEC. So in UR Power, that was a 22-day extension, which Mr. Justice Gross said he would have been minded to grant. And in PEC, it was Mr. Justice Hamblin, as he then was, considered an 8-day extension to be appropriate in light of the short length of the delay, the uncertainty as to whether the time limit applied, and the lack of prejudice to the respondent. All of those are factors which would apply here as well. See paragraph 21 of that judgment. By contrast, my lords, the cases in which extensions have been refused tend to involve very long delays for which the court has found the applicants to be culpable. So, for example, in Culmneft itself, there were extensions sought of 80 days and 103 days because there were two applications, and Mr. Justice Coleman found that the applicant's behaviour was totally unreasonable, paragraph 65, and that their explanations for the delays were incomprehensible, paragraph 76. So another example is Turner Bahrain, in the authorities bundle at tab 7, in which Mr. Justice Popplewell, as he then was, refused a 118-day extension, where the applicant was found to have engaged in deliberate and tactical delay, for which culpability was very high, paragraph 74. So, as I say, I don't urge this point, because I accept these are all first instance decisions exercising a discretion, but insofar relevant at all. This case is somewhat bucks the trend. Yeah, it supports my submission that this was an irrationally harsh decision. My lords, unless I can assist.
No, thank you very much. We'll start again at 2 o'clock.